Yep. And you can just like, you know, like I really found my answer.
Yeah, right.
And then all
and then we will
Hey guys, let me get your attention right quick. I think I got everybody in here. All right, so quick announcements. I went over this one time before. Keep your mask on at all times. Do not let these doors swing. Do not say man. Yes, no, judge, your honor. Just don't say man. If you have a pen and it clicks, don't let it click. Absolutely no talking, and do not rest your arms on these benches at all. Keep your mask on and pulled up at all times, even if you're talking up here. Yes, sir.
Will the court want us to address up there, or will the court want us to stay
Because
here?
there's so many of you guys, it'll probably be from here, but she'll let you know. She'll give you
Fine.
the
Clients will be coming in how? One by one, or together?
No, they're going to, we're doing it in the first service. But she'll address that. Oh, it comes down.
Thank you, sir.
All right. You guys have any questions for me? Everybody good? Good. All right.
Thank you. Certainly, thank you.
Yep, it's on it. Yeah, the green's out.
Hey guys, we're about to get started.
So in your folder, it is one file. This file, your response has her name.
Okay.
Just so that when you look down, you don't go, wait, you don't have it on there.
Ma'am. All rise. The Federal Court for the County and Legislative Circuit now assessing Honorable Judge Kimberly M. S. My eyes presiding. Court will now come to order.
Morning, please be seated.
Morning.
All right, I just wanted to give council an idea of how we'd be proceeding this morning. We are proceeding for the arraignment hearing in the matter of the state of Georgia versus Jack Morgan Beeman et al. Council, what I want you to know is that I will be arraigning the defendants in groups. Given the number of defendants we have, we obviously cannot fit everyone in the courtroom because, as you all see, even with all of the attorneys here, we'll have some challenges. And so I have asked my staff and the Sheriff's Department to arrange the defendants in groups of 30. The first group will be 30, obviously the second 31. I think there are 4 or 5 defendants I understand who are either being processed out of the jail or who for some reason are not present, and I'll cross those bridges when I get to them. Once the defendants arrive, I will ask counsel to step in front of the bar with your respective clients. I will bring the defendants up 5 at a time. My only information will be obviously related to the charges in the indictment and to ensure that they are aware of the charges. I've been in contact with the Public Defender's Office and the Conflict Defender's Office to ensure, to the extent possible, that we were able to determine which defendants needed counsel, which is why I've asked the Public Defense Bar to be at the table. Ms. Harrison, I'd like for you to take the lead because I know you would have had to file the paperwork for any defendants who were contacted by your office or contacted your office requesting representation. Mr. Regas, Ms. Walker advised me that you would be standing in as it relates to any defendants who have not been appointed counsel so that we can move that process along. And certainly for purposes of the arraignment today, is that correct?
That is correct, Your Honor.
All right. I will be moving the case from the arraignment hearing to the final plea calendar, which is the way that I generally move criminal matters forward. It's my expectation that these cases will stay together. And so once I have moved the cases along, they'll be moved along together. At this point, for the benefit of the state, I'm sure that you are aware there is a single demand for speedy trial that has been filed. We will take that matter up. And I know that there have been a couple of requests for extension of the statutory deadline for the filing of speedy trial demands. I will be taking that matter up as well. I can tell counsel generally that we'll be trying to get those matters heard today so that everybody will know when we leave how we're going to proceed. So my only question for counsel at this point is there anyone in the courtroom who do not anticipate that you will be waiving formal arraignment for your client? If you are not waiving formal arraignment on your client's behalf, I'll need you to rise to your feet. All right, for the 3 of you, you will need to read the indictment to your clients. We will not be doing that in open court. And once you've done that, you can report back, questioned by the court so that I can ensure they're aware of the charges. Ms. Harrison, I presume that you have the indictment?
Yes, Judge, and
All
if
right.
it be okay, I can remain in here today and then do that at a separate time if the court would like.
No, today's the arraignment hearing.
Yes, Judge.
So I guess we'll have to do it at the end of the day if there are announcements that you need to make concerning defendants who are on the calendar.
Yes, Judge.
I don't intend to have subsequent arraignment hearings. I think that's inefficient.
Understood.
So today's the day. The young lady who's standing, I don't know your name.
Yes, Jennifer Hyman.
Ms. Hyman, you have the indictment to read to your client?
Yes.
All right. And Mr. Menez?
Good morning, I'm Charlotte Jimenez. I have the indictment, however, Your Honor, the indictment
In this
So, Mr. Jimenez, that's not something the court will be providing to you today. We can deal with that in a subsequent motion. I don't know that that's necessary. For purposes of arraignment, if you're requesting that that information be unsealed for some reason, you can file an appropriate motion. But otherwise, you should be able to read the indictment that you have to your clients, correct? All right. Who is appearing on behalf of the state?
Good morning, Your Honor. John Fowler on behalf of the state of Georgia from the State Attorney General's office. With me is Hallie Dixon from the State Attorney General's office as well.
You said Hallie Dixon?
Yes, Your
Yes,
Honor.
Judge.
All right, spell your first name, counsel.
Hallie,
Thank you.
and the last name is Dixon, Judge.
All right, that's what I had, the traditional spelling. All right, so you want me to take your seats? Are there any questions from the defense bar before we start trying to move folks in and out? All right, if there are none, yes.
Good morning, Your Honor. Amanda Clark Palmer. Will the court be letting defense counsel inquire about the bond amount and the fact that some of the bonds do not specify that they can be made through the sheriff's 10% program?
Yes, so when I take your particular client's case up for purposes of arraignment, if there are outstanding bond issues, bond matters, then I'm happy to take those up at the appropriate time. It's my understanding that for most of the represented defendants, the bonds have been arranged and have been consented to by the state. Is that correct, Mr. Fowler?
That's correct, Your Honor.
All right, so I don't expect that should be a problem. I can't speak to the 10% program, but yes, that's how that will be addressed.
Thank you.
Anyone else? All right, so
Good morning, Your Honor. Molly Armour. I am a pro hoc vice applicant. Will we be addressing that when the clients are called?
so here is, we will, but I will tell you what my position is regarding pro hac admissions. I'm not interested in anyone appearing for purposes of the arraignment hearing. If you enter an appearance, you're in the case until its conclusion. If you're prepared to do that, then I will consider your motion and you will have to attest to that fact in the motion and application you've made to the court. In the absence of that, you will not be granted pro hac admission, you or anyone else. Fair enough?
Thank you.
All right. Anyone else? All right. So I also want to tell you all finally before we move on, I don't know if the Attorney General's office has served any of the discovery in this case on any of the defendants who have counsel. Has that been done?
Your Honor, only one person has given us a terabyte drive. That was Mr. Jimenez. He dropped it off Wednesday or Thursday. I filled it with the 2 terabytes available on that. There are approximately 5 terabytes of information in this case, discovery. It is large. But there are 2 different ways we're approaching it. The first is if anyone wants to bring us a 5 terabyte drive. The transfer takes approximately 24 to 28 hours from one computer or from one hard drive, the large hard drive that we have, to another one. We're also getting the assistance of our civil side to use the program that they have, and we have engaged them to upload it to that so that attorneys could have electronic access to it as well.
And what program is that?
It's called Relativity.
All right. And do you know at this point how many of the defense attorneys have opted into discovery for purposes of disclosure?
Your Honor, pursuant to the statute, I believe that once one co-defendant opts into discovery, it automatically opts in every other defendant unless they're severed off from the other defendants. In terms of how many, if I'm estimating, I would say probably 45 of them.
All right. All right. So, counsel, for members of the defense bar, you've heard Mr. Fowler's announcement regarding, you can take your seat, regarding disclosure of the discovery. I would ask you to govern yourselves accordingly so that you can make whatever arrangements you need to make to obtain all of the discovery so that we're otherwise ready to proceed. As it relates to the 5 gigs of discovery that you will be providing, Mr. Fowler, since most of the members of the defense bar have not had an opportunity to review it, for purposes of scheduling, I'd like to move this case into the early part, probably the first quarter of 2024, for a final plea hearing. The question for the state from the court at this point is, based on the amount of discovery that there is that going to be a reasonable period of time?
If I begin transferring every single one of them one a day and each one transfers one a day, it will take me 60 days almost exactly to do that because I've already started transferring one of them. So, yes, I believe so. If it was towards the later quarter of The later end of the first quarter of 2024, yes, Your Honor. I think if it's in January, I think that may be pushing it a
The
little.
date I was thinking about was March.
There's no objection to
The
that.
1st of March. Well, I understand you don't have an objection, but the defense bar really isn't in a position to state one way or another.
Understood.
So I'm simply trying to determine if it's reasonable, and so that you are aware. I don't like setting matters down just for the sake of setting them down and continuing matters. That's not the way that I manage cases. And so the date that I set is a firm date. It's the date that I will announce to the defendants, which means it needs to be a date that provides a sufficient amount of time for the defense bar to review the discovery for whatever discussions that you all intend to have regarding pleas, if there will be any such discussions, to be in a posture that the case is ready for a final plea hearing on the date that the court sets.
Your Honor, in that case, I would ask for an additional 30 days if the court is willing to give it to maybe April 1st. There are a lot of complicated issues, many finances, a ton of body cams, all of that sort of stuff, and it requires a significant amount of review. In a lot of ways, there is not a single CID file, if the court will, that you can use as a jump off to all of the other discovery in the case. A lot of it comes from other places just because there are multiple investigative agencies, both local, state, and federal. So we'd ask for an additional 30 days if the court is willing to give it.
All right. Ms. Harrison,
Yes, Judge.
I'll give you an opportunity to speak generally on behalf of the defense. I know this probably is odd because you've not seen the discovery, but based on the information Mr. Fowler has provided to the court, is there anything that you wish to tell me?
Judge, I would just have concerns that 5 terabytes of information, if it's going to take Mr. Fowler about 60 days to review that, that places us getting the discovery, hypothetically, if I'm number 60, at the end of January. I would have concerns
The end of
about,
December.
At the end of December, yes, Judge. I would have concerns about our ability to do that in that amount of time.
So assuming that all of the discovery has been provided to defense counsel by the end of the year, assuming that you have the discovery, then how long do you think it would take you to review it and be ready for a final plea hearing?
And it's 5 terabytes of information, Judge. I would say 90 days.
All right. So if the court sets it then for 6 months out from today, that would take us through the end of December, giving a few extra days for the state to complete the disclosure, and 4 months at the top of the year for counsel to review the discovery, have whatever discussions you intend to have with the state, and be ready for a final plea hearing. We then would be looking at probably April, maybe as late as May. Is there anyone in the defense bar, based on the discussion the court has had with Mr. Fowler and Ms. Harrison, who has questions regarding the timeline or concerns?
No questions, Judge. Michael Schwartz for Francis Carroll. That's without seeing the discovery, without knowing what it is, there's just no way we can agree to that. There are 52 days left this year, I believe.
We're at the end of, well, we're talking about starting after the discovery would have been produced, as I've indicated. So I'm going to give that process until the end of December.
Understood.
So that would be the end of December for the disclosure of all discovery, and then 4 months, the top of the year, for counsel to review the discovery and be ready for a final plea hearing.
If we were talking about 4 months from the end of discovery, whenever that is, potentially that's reasonable, but depending on the discovery, I can imagine it requiring more than that.
Anyone else?
What is the court's practice concerning motions hearings? I anticipate several motions where I'd be requesting a hearing before the court, and some of which would involve the discovery.
The court will schedule the hearings once the motions have been filed. I can't tell you any more than that.
Okay. So,
I try to hear the motions prior to the final plea calendar, provided they're timely filed. But again, it's difficult to set meaningful deadlines because the discovery has not been turned over. So that's the issue for the court. All right, you can take your seat. All right, so for now, based on the information the court has received, I'm going to set the final plea hearing for May of 2024. The date certain will be provided closer in time. That means that some of the parties I anticipate will have as much as 6 months to review the discovery based on the schedule Mr. Fowler has announced and the process by which the discovery will be copied and provided to counsel. The date that I set is I expect to be a firm date, barring extraordinary circumstances, and so you will need to review the evidence with some haste. To the extent that there are motions to be filed, those motions will need to be filed not later than, I'm going to say March 15th. Which will provide some opportunity for the court to schedule, I am hopeful, before the May final plea hearing date. And let me adjust that. The final plea hearing will be in May or June of 2024. Depends on the number of motions that are filed, how long the court will need to hear those motions, but I don't want to push the case back any farther than that. Is there anyone who has an objection to that? All right, so that will be the general timeline. That's the information that will be provided to your clients. And Mr. Fowler, I don't know if there's someone in your office who's working on copying the discovery now. If you're waiting on, are you waiting to do that until you receive hardware from the defense bar?
Yes, Your Honor, as I was sitting here, I was thinking I have a separate one I can transfer it to two and perhaps transfer it possible.
What is that? Can you mute? Whatever it is, it appears to be. Can Gina do it? I can't, I don't have it on, so I can't see. Could you all move out of the way? I can't see the Zoom. Do you know where it's coming from, W. Williamson?
It's coming from the monitor.
I know it's coming from which courtroom?
40.
Thank you. I need you to stay at your desk so I can get you on call 4 being muted, please.
Can y'all see him? I just muted everything, so I don't know how. Just give me a second. I'm working on it. Technology.
Hello? You can't get it? What is he doing by one? All I need is 4. I can't tell. I'm looking at the box. It's still highlighted, so it looks like it's not been turned off yet.